Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We are pleased to have back in the studio phenomenal guest every episode, real estate attorney Sam Chuck. Sam, welcome.
Thanks, Pat. Good to be here.
We have an executive producer tonight, Stevie Chuck. Glad to have him in the studio as well. Now, there's a lot of new laws, so I'd like to go over a few of those with you if we could.
Sure.
Okay. What about, of course, with the mortgage meltdown, there's a lot about valuation. Perhaps that was a little off.
Well, every year they bring out a whole new set of laws to try to provide more protections, usually addressing something that was an issue that's been reoccurring over the past few years. And like you mentioned, one of the big problems that caused the mortgage meltdown is you had a lot of appraisals that were being done on properties coming up with values that weren't really legitimate.
Correct.
But they were good enough to get the home loan or the refinancing. So what they've really done recently is codified what was always a good practice, and that is if a real estate agent is going to be involved in providing some type of value information, if that broker is going to give an opinion of value, if they're going to have contact with the appraiser, they cannot have any interest whatsoever in the transaction. So that results in two things. First, if the broker actually gives an opinion of value, for trying to secure a loan of some type, that broker cannot be involved with the brokerage that's handling either the buyer or seller, can't be involved with the seller or buyer, can't be involved with the lender that's doing the transaction. They have to be a true independent third party. The other part about it that they've codified, but it's always been kind of the case, is a licensee, a real estate agent, whether they're a salesperson or broker, cannot have such things as bribery and coercion, but more importantly, they can't have any attempt to have influence on whoever's providing the value information. It was not uncommon years ago for, if a buyer was, securing a loan, that, while they're waiting for the lender's appraiser to come in with a value, that their broker's calling that appraiser, hey, here's another comp, I don't think your value's right, you should reconsider this, putting pressure on the appraiser to come in with the number that, the value or the price that broker was trying to get the deal done at. Now, any action like that can be a violation of their licensing requirements.
Now, in the past, the appraiser was under the gun because if he didn't cooperate, his phone wouldn't ring again.
Exactly.
So that was a
And
problem.
that's largely changed too, because there used to be a really strong referral network between brokers and appraisers.
Correct.
So a broker had a deal, and like you say, they're calling that appraiser, come do the appraisal. And as long as the appraiser was on the lender's approved list, they could get that deal done. Now they've really separated that much more. Actually, you kind of see, especially in this valley, you're seeing more and more brokers coming in from areas you wouldn't expect them to do. I saw one recently. It was a home in San Jose, Willow Glen area. They brought the appraiser in from Fresno. Now, I don't know if that's the best thing for somebody to have local knowledge, but you definitely see the separation that they're trying to create where appraisers and brokers don't have any type of relationship.
So now there's that third party where the loan company will call up an appraisal company, and then the appraisal company will choose what appraiser goes out.
Or they'll contact an appraisal company that's approved, but they're typically not people that have relationships with the brokers. So it's not the broker making the contact, it's the lender.
Got it. Okay, this is interesting too, a small claims court.
Yeah, this is just a small change, but it's actually important to a lot of people. One of the things that's really limiting about our justice system is the cost. Lawyers are not cheap. It costs a lot of money to go through the process. And that's really problematic for a new home buyer or a homeowner when the amount in controversy is not that much. And so what they've done is they've changed in the small claims forum, they've upped the amount that you can sue for. A long time ago it was $5,000, then they upped it to $7,500, and now it's up to $10,000. So that means if the amount in dispute between two parties is $10,000 or less, you can go to small claims court. Now, a couple of things to keep in mind. In small claims court, you can't be represented by an attorney. So even if your Uncle Phil's an attorney, he can't show up to represent you. You can consult with an attorney in advance to kind of understand how do I present my evidence, what is the law on my issues. But it gives you an opportunity to save those costs of entrance to the legal system and get a case adjudicated. One other thing I'd say to people at home that they should keep in mind is often people assume that if the amount in controversy is more than $10,000, they can't go to small claims court. That's somewhat true. And why I say that is, let's say you and I have a dispute and I think you owe me $14,000. I can go to small claims court. I can only get 10 though. So the reason I mention that is because you may say for the extra $4,000, I don't want to hire a lawyer. I don't want to pay the higher filing fees. I don't want the longer litigation. Small claims court is relatively simple. I file my claim, the other side answers, we show up and put on our case. When you file a civil case, I file the lawsuit, you file the answer, the filing fees are higher, and then there's the ability to what they call discovery, take depositions, serve interrogatories, written questions. It gets much more expensive of a process. So if you're close to that $10,000 that you're seeking, you can just say, look, I'll cap my recovery at $10,000. You'll walk into court and tell the judge, look, I think I'm entitled to $14,000, but I know I can only get 10. I'm going to show you he should have paid me 14. Give me the 10 I can get by this court.
Okay, this is one example is people often fight over a deposit. So sometimes if you go through the legal system with attorneys, the fees could be more than a deposit.
And it can be. Now the difference with a deposit dispute is a deposit dispute typically arises out of a contract. And meaning you've got a written, California Association of Realtors contract or some other local contract like PRDS. Those have attorney fees provisions. So one of the beneficial things is, yes, you have to pay those fees, but you're entitled to recoup them. You're entitled to get a judgment not only for your deposit, but all the attorney's fees you incur to get those. So they're a little different, but you're right. If it's a simple deal in which the deposit's like 10 grand, you may be better served just to go to the small claims court.
Because in the case that you gave with the contract, in the real estate purchase contracts, if you lose, you have to pay your own attorney and
their attorney. Yeah. Attorney's fees clauses are wonderful and negative all at the same time. They're wonderful if you win and they're terrible if you lose. But what's interesting about it is the existence of those clauses, those attorney fees clauses, often are what causes cases to settle. Because if you and I have a dispute about a deposit, and let's say, for example, I'm the buyer, you're the seller, you have my deposit, and I want it back. If I sue you, and you're sitting there thinking, well, wait a minute, I might lose this, plus I got to pay his fees, knowing you might have to pay my fees as well, you're probably more inclined to give me my deposit back. If there were no extra fees, you'd kind of feel like, what's the harm? What's the worst that happens? I give them the money back, or I keep it, no harm, no foul. When you realize that you've got those attorney's fees as potential further exposure, that often gets the case settled quicker.
Got it. Okay. Now this, in California, we have a problem with drought and water conservation. This is an interesting law here.
Yeah, what they've changed is it deals with the transfer disclosure statement and the disclosures regarding the type of law that's being put into effect with respect to water conserving plumbing. There's a statute that goes into effect that says by January of 2017, a single family home that's built after 1994 has to have water conserving plumbing in it. The law has also changed with respect to the transfer disclosure statement. Now the transfer disclosure statement is the document, as you well know, that by statute every home seller has to complete. They have to fill out all the information about the house.
Sure.
So a buyer has some basic understanding. What they've changed in that law is they've added one more box, one more piece of information that a seller has to tell a buyer. And that information is there water conserving plumbing in this house? And it's now becoming relevant because that homeowner is going to be bound by that law in the not so distant future. So they want to know, am I going to have to make replacements to comply with the law, or is the home already in compliance?
Got it. Okay. Next up, We don't see too much of this here, but the mining operations. We have to disclose if there's a mining operation close by?
Yeah, this is, I don't expect this one to be a common problem, although you pointed out when we were talking a moment ago that there are some local mines here in the Santa Clara Valley, by example.
Sure.
But basically what they've changed is if you're within a mile of one of those designated areas, you need to disclose that there's a mining reclamation facility nearby.
Okay, this reminds me, a couple of years ago, they had a similar situation for former military bases where they would fire off rounds, and kids would be out playing in the sand dunes and find a World War II bomb that hadn't exploded yet.
Right.
So we have 58 counties in California, so plenty of abandoned mines as well as abandoned military fields.
Right. And it's a real, this is another one of those supplemental disclosures that really comes out of geographic specific areas. But like I said a moment ago, I was surprised because you spouted off two right off the top of your head here locally.
Sure.
But sometimes you forget because they have been abandoned for 20 years, 30 years, 40 years.
Right. Now this is, speaking of the difference between the counties, in Southern California we have independent escrow companies, where in Northern California we typically have an escrow company that's operated by a title insurance firm.
Right.
So what's the difference there? What is the purpose of the escrow and how does it play out?
Well, escrow itself, oversimplified, is really just that person who's going to serve as the intermediary, who's going to say from the buyer, I'll take all of your cash, and say from the seller, I'll take your grant deed, the document that transfers ownership. And once I have them both, I'll switch. That's really what the escrow officer does. But you got to think about that. You're putting a lot of trust in that person because they're taking all the cash and they're waiting for that document that says I'm transferring ownership. And when they have them, they switch. Well, obviously, if they take the cash and put it in their pocket and leave town, you got a problem. And one of the things people don't realize is the regulations governing escrows and escrow officers are not that stringent. There are not heavy insurance requirements, licensing requirements, as much as you would think when you consider the volume of money they're dealing with. So when you look at what kinds of escrow facilities are out there, you're right when you say there's two kinds, oversimplified. There's the escrow service providers, and sometimes they can just be a licensee by the Department of Real Estate, or there's title companies who have escrow departments. Either one can fulfill an escrow, but you, in my opinion, you want to try to find the one that has the greatest financial stability to make sure that your transaction is going to happen the right way. Now, if you take a title company, for example, they're in the insurance business, really. They sell title insurance. Just like you buy life insurance or health insurance, you buy title insurance, which is insurance that after I give you that money, I really own this house. And the insurance company is insuring me, I own it. Nobody else owns it. This guy selling it to me wasn't a fraud, I own it. That's why I buy the title insurance, I'm insured. Well, those title insurance companies are parts of very large insurance companies. So their escrow departments are backed by very large insurance companies.
Right.
So if they do something wrong and you go and sue them, there's a lot of money behind that, a lot of insurance behind that escrow officer doing the right thing. Now there are very good, competent escrow providers that are not part of title companies. So I don't mean to exclude one over the other.
That's right.
But when you're looking at an escrow provider, you want to be extremely careful and make sure you're using the best. The recent law change really was one more with respect to those independent escrow officers reporting to the Department of Real Estate at the end of the year. So if they do 5 or more transactions or over $1 million in transactions, they need to notify the Department of Real Estate, here's all the transactions I did, here's what's going on.
I see. So sometimes there can be a real mom and pop operation.
They can be, although those are lesser and lesser now, but they're still you see them mostly in the smaller counties, but usually they're built on their word. They've got a long reputation where everybody knows them and trusts them.
Right. When I was new in the business, there was a branch of 3 small escrow providers. That's all they did is escrow.
Yeah.
which I think they're long gone now. But
Yeah.
they'd probably been around forever. All right, this is a topic we have a lot of problems with, that on the courthouse steps, people are gathering to sell the property, and perhaps there's a stay of execution, so to speak, for whatever reason.
Well, foreclosures have become extremely, prevalent in the downturn of the economy. And one of the problems that was happening for most homeowners and potential buyers is they really didn't know what was going on in the foreclosure. And these lenders and the people handling the foreclosures for the lenders had so many foreclosures going, they didn't even know what was going on. And so, here I am, if I've had a foreclosure happening, I'm trying to find out, is the sale happening? Is it not happening? If I'm a buyer, do I show up to bid or do I not? How do I bid? What's the risks of bidding, and so forth. So what they did is they changed the law really from a standpoint of requiring those lenders to give much better notice, much better access to information. It was not uncommon that you'd have a foreclosure and you'd receive the notice and it would say, foreclosure sale February 9th. Okay. Well, then there would be conversations with the lender where you're trying to work something out and you'd make some payments and they'd say, we'll postpone that foreclosure to May 9th if you pay us this amount of money. And the homeowner pays the money and they're thinking it's postponed and they got no notice, and sure enough, the sale happens on February 9th. And in California, when a foreclosure sale happens, if it's to a bona fide buyer, it's over. So you may have a claim against your lender or not, because the law really doesn't support those kinds of claims, but that house is gone. It's sold. So what this law does is it requires those lenders to do two things. One, when they give you a notice of sale, they've got to give you much more complete information on when it is happening, how you have the right, what kind of rights you have to postpone that sale. And then for a buyer who looks at that notice, it tells them about the risks involved in understanding foreclosure.
Oh, interesting.
I've seen a lot of people buy foreclosure property after watching some infomercial at midnight thinking, I'm going to make a fortune, and find out they just bought, a complete nightmare. The other thing the law does, which is really, really practical and helpful, is it requires the lender to put information accessible. So a web page where you can look up that particular foreclosure and see, is it going or postponed?
Perfect.
A toll-free number, something so the general public isn't sitting there going, oh, do I have to go to the courthouse steps this morning to confirm that foreclosure sale is continued? All that said, I do want to give one word of advice. Even if a website or a phone number tells you your foreclosure sale is postponed, it is my belief that the best practice, let's say you're the homeowner and you don't want your house foreclosed, you want it postponed, go to the sale. The reason being is the sale time, even if they post it on the internet or even if they put it on the toll-free number, that lender still has to have the person who calls the sale show up at that notice time on that courthouse step and notify everyone of the postponement.
Oh, I see.
I have seen mix-ups where yes, they post it, yes, they tell you it's going to be postponed, and 99 times out of 100, that's fine. But I've seen times where the caller, the person who conducts a sale, doesn't get the notice, and they conduct the sale. And when the sale's done, the sale's done. So I always tell people, go and be sure. Stand on the courthouse steps, wait for the guy to say, okay, 123 Mulberry Lane is now continued. And if he says is up for sale, you say, hold on, that's continued. I've got the printout from the web page, I got this information.
Oh, good.
Because usually, if a caller, a person calling the sale, has someone stand up and say, wait a minute, that's continued, they'll stop and call headquarters.
They will stop the sale.
They'll stop the sale and they'll say, this sale's now on hold. I'm going to go to my next sale. When I'm done with these, I'm going to call and find out if I'm supposed to continue with this sale or not.
Now, in the past, it's my understanding the caller is the only one with the real phone number who can really call somebody at the bank and find out.
Yeah, that's true.
Okay.
They're the person with the information about does this sale go or not.
Now, in terms of the seller wanting to stop the sale, they might have come up with some payments or come up with some money to put off the sale, or they may have sold the house and a week before and said, let me sell the house and pay you off, right?
Right.
So that's another way to avoid a foreclosure.
And there's a lot of ways to get a bank to agree to postpone the sale if you're going to get them either paid through payments, or you're going to get them paid through selling it. You talk about short sales. You're selling it with the lender's permission to sell it for a little bit less than the loan. There's ways to do that, which often result in foreclosures being postponed. But what's important to understand is that foreclosure, when conducted, is final. So even if you're on the phone, and I've seen people do this, they get on the phone, they talk to some lender representative, maybe they hear what they want to hear, maybe the lender representative misrepresents things, but they come off that phone call thinking that foreclosure sale is postponed. Well, now there are websites and phone numbers you can call to make sure, and if it's not postponed, or even if it is, you want to show up and just double check, because otherwise you'll lose your house.
Okay, so that brings up a good point, because sometimes this home has been for sale for a while. They finally sold it for a third time. They're going through the short sale process. They have a deposit in escrow that we just spoke about, and the house is sold on the courthouse steps. That's probably a pretty tricky situation.
It is, and I mean, for the seller of the home who has now lost their home to foreclosure, it can be a whole host of problems, because remember, they have a contract, they're agreeing to sell this home, and they can't perform on that contract. So typically, if you get a really competent real estate agent like yourself, you're handling with the short sale addendum, you're keeping the lender in the loop, you're making sure that sale doesn't happen. You're dotting the I's and crossing the T's as part of doing a short sale or selling a home in foreclosure. And that's why it's really important for people to understand that when that foreclosure is pending, when there's a notice of default, you need to be working with a professional that really understands all these nuances. Because if not, you can think, oh, I'm selling my house to my neighbor Bill, and everything is going great, and I'm saving my real estate commission, and I don't need anybody, and then all of a sudden the house gets lost in foreclosure. Wait, I talked to the guy on the phone, he said it'd be all okay. Well, maybe what he said was, yeah, if you sell it before the foreclosure and get us all the money, we won't foreclose. But that's not what they heard, and so you got to make sure that somebody's on top of this. Okay. But at least with respect to new laws, you've got better access to what's happening with the sale.
That's fantastic. That's got to be the winner here. Well, this is another tricky situation with these homeowner associations charging for documentation that the seller has to provide to the buyer. When I first got in the business, it was $75 and $150, and now it's up to $300, $400, $550 to gather these documents.
Yeah, it's gotten ridiculous, because when you're in a planned unit development like condos, or even when you've got a small single-family homes that are detached, but they're in a planned development with gated development. One of your obligations as a seller by law is you have to disclose all the information about the homeowner association. How much money do they have in the budget? How much reserves do they have? Are there any known claims about any of the homes? Like, let's say they got a defective roof or defective siding. Are they going to be taking money to redo the swimming pool, or the main house or whatever you call common area house that people use for parties? All of that information has to be disclosed. Now, there's a HOA packet, a homeowners association packet, that typically a real estate agent calls on and says, prepare the packet. And like you say, it's gotten more and more and more expensive. What the new law does is a couple of things that's pretty helpful. One is it puts some checks on those costs that they're charging you. Two is, if all the information is available electronically, if they've got it all stored, which they should. In today's day and age, they should have it. They have to provide it to you at no additional cost. They just send you the email with the information. Right. And also, what's really helpful is now they have to, if requested, they have to provide 12 months of approved minutes of the association. And I always tell people, when you're dealing with a homeowner association, what you really want to look at is not just the accounting with here's our reserves and so forth. You want to see the minutes of the meetings. You want to see what the homeowners are discussing.
Right.
Are there complaints about dogs? Are there complaints about loud noises, partying? Are there complaints that everybody's running into the same problem with their garage door doesn't work, or whatever it is? 12 months will give you a really good feel for what are the ongoing complaints at that place. I've seen homeowner associations have serious problems with drainage, where the sprinkler system wasn't installed properly, or the water table is high, so they're getting moisture underneath the condos. Nobody, you go get your budget for what they're saving money for. That doesn't tell you it, but you go back to 12 months of minutes, and you're going to see that issue discussed a lot.
Okay, last question. We got 1 minute here. This is really important. With the HOAs, there's a new law about being a landlord when you move out and you want to rent out your unit.
Yeah, real quick. Homeowner associations can change the rules on what you can do with your home. That's part of the rules that exist in a homeowner association. One of them you've seen them change is, well, we've decided we don't want any of these homeowners association units, any of these condos, turned into rentals. So we're all going to take a vote, and if more than 50% vote, the new law is nobody can rent their condo out. Well, that's debilitating for a property owner not to be able to rent it. The new law says from this date, beginning of 2012 forward, you cannot implement a law prohibiting renting on a property that was not previously restricted. So when I owned it, it wasn't restricted, you can't then put the restriction. Mm-hmm. The restriction can be there if it's in existence after I buy it. Mm-hmm. So if I'm the original owner, they can't put the restriction. If when I come in, they tell me, hey, by the way, no renting, then they can put that restriction.
Perfect. Sam, Chuck, I want to thank you for coming out here tonight.
Oh, my pleasure.
And we want to thank Stevie Chuck, our executive producer, for coming down here. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within a residential real estate arena. We will see you next week, same time, same channel. Thanks again.